Whenever you're ready, I'll tell you what we're thinking.
Okay, so do I need to go through the motion and then get an updated report?
Not if the court agrees with what we've proposed.
Okay, I guess before you even tell me what it is, I'm probably going to want all the information on what he's been doing and the new offenses, but tell me what you're thinking.
We are thinking Safe P might be appropriate, Your Honor, since he was put on probation on the 2 felony cases up in Smith County. I had also extended a time offer of 3 years, which he considered, but I think his preference is, if the court let him, do Safe P. We have a lot of counts here. Just so the court is aware, originally this MTRP was filed when he no-showed a judicial review on November 4th.
Okay.
And then shortly after that, around November 25th is the offense date for the Smith County cases. And so that's what the first amendment motion was for, and then the second, that was adding a misdemeanor related to this.
So in Safe P, I'm looking at this. I guess, what is the allegations for why Safe P would be appropriate? Is there a drug issue?
There's certainly...
Yes, in September and October, there is on count 6, an allegation that he was intoxicated.
Mm-hmm.
And Judge, I'll tell you, the Smith County cases arose out of an altercation with a girlfriend and a friend, where apparently they disposed of pills of his, because of how he was acting, and he threatened her and pulled a knife on her, and then assaulted the other friend. And that's what I believe he's pled guilty to and been sentenced to probation in the city of Tyler in Smith County. So obviously there's a drug issue. His history is, as a juvenile, for what we're hearing now and for what he did in Smith County, all involve assaults and some serious problems with violence, if you're all right.
And I do think Safe P would be appropriate as well, Your Honor, because in regards to the November 4th date, which he failed to appear for his administrative hearing, he was in the hospital due to some self-harm. And so that was the reason why he did not appear on that day, because he was in the hospital.
So whatever the court wants to do, we're fine with. We just wanted to let you know what we thought as a possible solution.
Why do you have a black eye?
I got hit.
Got into a fight in jail?
Yes, ma'am.
Anna, you have his...
I reviewed that report, Your Honor. I guess you can...
The court moves carefully, making sure every defendant understands the consequences and opportunities before them. Celine Reinhard, charged with a second-degree felony for assault on a peace officer, has the formal reading waived, and the state proceeds on a lesser included Class A misdemeanor for resisting arrest. She pleads guilty freely and voluntarily, confirming that she reviewed all documents with her attorney, understands them fully, and knows that following the plea agreement waives her right to appeal. The court places her on 1 year of deferred probation orders, a $500 fine, and emphasizes that full compliance offers a chance to have the case dismissed, avoiding a conviction on her record. Any violation, however, could return her to court and result in a sentence of up to 1 year in Jefferson County Correctional Facility. The trial court certification is handed over, and probation staff prepare to guide her through the required paperwork. Meanwhile, 20-year-old Miss Clannon is granted a 30-day reset to hire legal counsel, with instructions to consult at least 3 attorneys and return documentation of her efforts, ensuring she is fully prepared for the next court date.
I'm going to read it anyway, but looks like somebody stole something from him in the dorm, and we can probably look at it, right? And there's an incident or two in the last few weeks also, more than one of, I think, disrespect to the guard.
So, Dan, why don't you tell me why you think I should not put you in prison today?
I've never really followed through with any treatment programs before, and kind of have to go to prison now, so I really don't want to go to prison, so maybe if I physically and obtain some of the information, I might be able to turn my life around.
And so here's the thing, you've been coming here for a while. And I've read about and we've talked about and I understand somewhat and empathize with what you've been through and where you've come from and the issues that you've had to deal with. But at some point, you have to take personal responsibility for the rest of your life and the circumstances of your life before. You have to be able to say, you know what, that was awful, it wasn't great, it wasn't fair, but I'm going to do something different and I'm going to quit doing the same thing over and over again and kind of blaming that didn't have a great upbringing like some other people maybe. Does that make sense? And it's going to be no one's fault at this point but your own.
The courtroom moves efficiently through several cases, each carrying its own weight. Rosindo OA, previously pleading guilty to evading arrest with a vehicle, has his pre-sentence report reviewed and the court confirms his competency and voluntary admission. Following his plea agreement, proceedings are deferred, placing him on 5 years of probation with a $300 fine and strict adherence to all rules. At just 21 and with no prior record, this is a significant opportunity. Successful completion could lead to dismissal and avoid a felony conviction with options for non-disclosure to limit the record's impact. The judge emphasizes the importance of compliance, noting early termination is possible for those who complete all requirements and warning that any violation could return him to court with a potential sentence of up to 10 years. Meanwhile, Ashley Sanders, charged with theft of service, receives a final reset to accommodate a forensic audit with instructions to stay in contact with counsel. Shai Brooks, also facing evading arrest with a vehicle, has his case reset to ensure proper communication with his attorney and review of relevant media, highlighting the court's focus on preparation, accountability, and due process.
You will be given, you already were given here, all kinds of opportunities. And I'm very hesitant to go along with this because what you're doing is not just using drugs and not showing up. It's the violence that I have concerns with, and that at some point I don't want it to be on me that I let you out, that you really hurt somebody or killed somebody or got yourself killed, because that's where this is headed. And understand that, was it Tyler County has given Smith County. So what about the Tyler County?
That's an error, Judge. I meant to correct. It should.
Oh,
Tyler, Texas.
It's the
but
confusion
Smith
between
County.
City of Tyler and Smith County.
So what? Let's do this. I'm going to print this out. So what they did in Tyler by giving you that opportunity kind of puts me in a position where if you're on probation there and I give you some amount of time, you're still going to get out and be on I understand why Mr. Nichols and Ms. Holmes have come up with this agreement. But I want you to understand that if I send you to Safe P, two things, and you're not the first person I've said this to today. You're going to have some amount of time while you're waiting in our jail to go to Safe P. And then once you get to Safe P, you're still incarcerated. And any incident reports that happen, any incident in our jail or Safe P is going to be a violation of your probation before you ever get back out. And I won't care what they're doing in Tyler. I don't care if they keep you on probation. You'll be done here. And it's not going to be for a little 3-year sentence. Do you understand that? So this is the opportunity. Those people.
The courtroom moves through multiple cases with a focus on preparation, accountability, and rehabilitation. GMO Galvin, facing a third or more DUI charge, requests a brief reset to obtain a scram device and demonstrate compliance with the prosecution, and the court grants a 30-day reset to ensure all results are in place for the next hearing. Alexandria Bledsoe, charged with abandoning or endangering a child, receives a single reset to consult with her attorney and review her plea options, emphasizing the court's attention to informed decision-making. Patrick Gallagher's case reveals a complex history: multiple probation violations, prior felony convictions in Smith County, and substance and violence issues. The court weighs the appropriateness of placement in a secure treatment program, considering recent intoxication, a prior altercation with a knife, assaults, and hospitalization for self-harm. Gallagher's own plea for help reflects a willingness to take responsibility, yet the judge stresses that empathy has limits. At some point personal accountability becomes essential and the consequences of past actions must be addressed before any chance at rehabilitation can take hold.
People at the jail that are working there and just trying to go do their job every day do not deserve for you to speak to them the way you do, to treat them the way, to not follow the rules. I'm not going to say on the record, but I guess my concern, if you really don't want to be in jail, the way you're talking to some of these people, like, I don't give a, if you write me up and you can't tell me what to do kind of stuff, doesn't make me feel like you're really going to be able to do this. If you really want to, it's up to you. It's just a mindset change. You're going to be given the opportunities, but I want to know, and I will be checking. My staff can check every day until you get to safety. Anything else happens, they're going to file a motion to revoke, and we're going to be right back in here within a couple of weeks if necessary. Do you understand? This is your final chance. That's it. Don't come back in and no excuses after this point. If somebody else gives you another chance in another county, that's on them. You're not getting another one with me. I want to go through the motion, though, because I want record of what he's either pleads true or not true to, so that I know kind of when I look back what we talked about and what we did and what was pled to before I agree to do anything. So, Mr. Wizard, the best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, put your hand down. And will he read the formal will he waive the formal reading of that motion?
Yes,
and so before we go, Mr. Nichols, did you want to make a
Judge,
amendment?
two things. I will drop count 1 for failing to appear at that hearing based on the conversation I had with Ms. Holmes.
The judge addressed the defendant with unflinching honesty, stressing that at some point personal accountability must take over. Acknowledging past mistakes, quitting repetitive behaviors, and stopping the blame game is the only way forward. She emphasized that prior opportunities had been given and the current concern was not merely drug use or missed appearances but the potential for serious violence. Clarifying jurisdictional errors between Tyler and Smith County, the judge explained that any probation or time in Safe P would carry strict consequences, including the possibility of immediate revocation for any incident reports before release. The defendant was reminded that jail staff were simply doing their jobs and deserved compliance, and that further misconduct would leave no room for excuses. With the seriousness of the situation laid bare, the judge instructed that any failure to follow rules would result in swift action, marking this as the final chance. Procedural amendments were made to the motion, including dropping 1 count for failing to appear and correcting the county for counts 9 and 10. The judge reviewed the defendant's prior probation from July 2024 for injury to a child, elderly, or disabled individual, noting it was a 3-year deferred probation, and confirmed that the allegation of not working faithfully at suitable employment was true. With this thorough review, the stage was set for decisions regarding extended probation or additional actions based on the pending allegations.
Okay.
And then on count 9 and count 10, change the county, which currently reads as County of Tyler, to County of Smith on both of those counts.
Any objection?
And I
Okay.
believe it's correct on the other. Okay, yeah, I think that's all I need to change, Your Honor.
All right, thank you. So, Mr. Wizard, I'm going to go through this motion. It shows in cause number 240198, you were placed on probation July 1st of 2024 for the offense of injury to a child, elderly, or disabled individual, and that was a 3-year deferred probation. Is that correct?
Yes, ma'am.
And I guess also, I'm going to go through this, but I am inclined, based on this, to extend that probation for some amount of time based on the allegations as well. So we'll get to that in a minute. Count 2 alleges that you did not work faithfully at suitable employment and provide verification of that to probation. Is that true or not true?
It's true.
Okay. Count 3 alleges that you did not provide verification of performing community service hours as required. Is that true or not true?
Probation wasn't transferred from one county to another.
Okay, I'll put not true there. Count 4 alleges that you were at a location other than your residence at 4:04 a.m. on September 24th, 2024. Is that true or not true?
Lovely true.
Okay. Count 5 alleges that you did not enroll in services at the Spindletop Center as ordered. Is that true or not true?
Not true.
Count 6 alleges that you failed to never become intoxicated or under the influence of any intoxicated substance, and that you were on September 27th and October 19th.
The judge methodically went through each alleged probation violation, with the defendant clarifying counts 2 through 12. Count 3 failure to provide verification of community service was marked not true due to a county transfer, while counts 4 and 6 being away from home and intoxication on specific dates were admitted as true, highlighting the seriousness of violating core probation conditions. Counts 5 and 7 regarding enrollment in ordered programs were found not true or abandoned, while counts 9, 10 and 12 involving arrests for aggravated assault causing bodily injury and assault on a family member were confirmed as true. The judge paused at the critical moment, acknowledging that legally she had sufficient grounds to revoke probation and impose prison, but instead exercised judicial discretion to prioritize rehabilitation over punishment. Probation was extended for 2 years, with orders to enter and successfully complete the SAFE PE program, including any follow-up treatment and support to address mental health needs and provide tools for reintegration. The judge emphasized that this was conditional trust. Any future violations, whether in custody or out, could result in revocation and imprisonment for up to 10 years. She clearly laid out the stakes while offering the defendant a structured path forward, stressing that this opportunity was contingent on full compliance. The defendant was instructed to take advantage of this chance, understanding the consequences of failing to do so before being returned to the bailiff.
Not true. Count 7 alleges that you failed to provide verification of entering and successfully completing the moral recognition therapy program. Is that true or not true? I'm not too worried about number 8.
We can abandon that count, Your Honor. Count 8.
Count 9 alleges that you were arrested for the offense of aggravated assault with a deadly weapon November 24th of 2024 in Smith County, Texas. Is that true or not true?
True.
Count 10 for the offense of assault causing bodily injury November 24th of 2024. Is that true or not true? Count 11 alleges that you were at a location other than your residence at approximately 19 p.m. on November 24th of 2024. Is that true or not true?
Not true.
Count 12 alleges that you were arrested for the offense of assault on a family member and by impeding breath or circulation November 24th of 2024 in Smith County. Is that true or not true?
True.
All right, so did you enter your pleas of true to counts 2, 4, 6, 7, 9, 10, and 12 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true? All right, then at this time, I'm going to find that you entered your pleas of true to those counts freely and voluntarily. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I am going to continue you on probation. I'm going to extend your probation for 2 years. I'm going to order that you enter and successfully complete the SAFE P program and any aftercare and things like that. The thing about this is you're going to get all kinds of tools at SAFE P to help you make better decisions, to get a grip on whatever you need to. If there is a need because of, I know there was some mental health issues and treatment, it might be that special needs SAFE P is the better. I'll let probation look at the history and see what's best for you so that you make sure you have the tools. When you get out, you'll have help to assimilate back into society and halfway houses and things like that. Again, this is your opportunity, because if you do not follow through with this, if you violate while you're in custody, if you violate again while you're out of custody, we will not be back here having the same discussion, and it will not be a discussion about 3 years or anything like that. You can be back in here, your probation revoked, found guilty, and I can send you anywhere in the range of punishment. I don't have to let them negotiate. It can be up to 10 years. Do you understand?
Yes, ma'am.
Okay, take advantage of this opportunity. All right? Okay, you can go back with the bailiff.